is to shift the power from a political to an apolitical body in terms of taking the decisions, the hard decisions that may or might lead to water conflicts. So in a sense, the adjudication of water conflicts is shifted from a political to an apolitical structure. Secondly, we have the proposal for either privatization or supply of domestic water by non-governmental actors. I've put it on purpose in very general terms, where here the aim is to move from the supply-led mode of government supplying water to addressing the identified scarcities through economic efficiency measures, where it is the economic ability of the users that determine their access to water. So typically in the case of rural areas with the Swajal Dhara scheme, we have a situation where it is the users that can pay for the 10% capital costs that get access to water, and that's the way in which the scarcity and or the conflict over access to available water supply is addressed. Thirdly, in a rather different direction, we also have proposals to strengthen state regulation. And there is only one example of that, but it's a significant example because it covers the whole of groundwater. And again, groundwater being the main source of water for most water users today, it is extremely significant. Here we have a different scheme where the idea is to centralize control over water as opposed to a decentralized system where it is each individual landowner that has control, or mostly control over groundwater. And in doing that, indirectly starting a process of delinking access to water from access to land. But it's only an indirect inference in the sense that that's not directly what Groundwater Act or the Groundwater Model Bill tells us. But because of the framework, the policy framework, policy and economic framework within which we are, it is clear that the groundwater legislation that are being proposed today, the ones that are being adopted in a number of states, do provide at some level the basis for trading in water at a later stage, because they provide the first step in the delinking of land and access to water. Fourthly, there is the proposal to shift the management of water towards user group. For instance, the so-called water user associations for irrigation in the irrigation context. And here one of the things, obviously there are many different dimensions that I'm not covering here, but just in terms of conflict. Here one of the things that happens and that is sought for is for the government to withdraw from the management in favor of the local users, local user groups, but in a framework where there is no accountability that's provided in the formal legal framework. So in a sense, it's not just the state withdrawing from the management itself, it's also the state withdrawing from the accountability frameworks that existed. Whether it was effectively used before is another issue, but the fact is that there was an accountability framework that was there. The most evolved, if I can put it that way, development in that sense is the UP Water Regulatory Authority Act, which specifically tells us that there should be no recourse beyond any decisions taken by the authority as an appellate body to any courts, any civil courts whatsoever. That doesn't actually bar appeals per se beyond, but it's very significant that the Act tries as much as it can to bound the system to the new regulatory authority. And since, in terms of water user association, there is no accountability framework at the local level and people are left to fend for themselves and fight it out among themselves, it is necessarily through those new regulatory authorities that the disputes will be adjudicated. Now, okay, so these are some of the responses that have been given in existing legal frameworks, in existing water law reforms. What else is it that we can think of? So I'm just going to highlight a few things as a way to get the discussion going. First, I guess we need to make sure that the priorities of water law, around which I guess most people would agree, are set right and put in a framework where they can't be changed. Okay, first of all, there is the issue of the priority for drinking water. Now, first of all, we have a problem that since we don't have a legislation for drinking water, the priority is only found in water policies. Water policies, again, are non-binding documents, and they are of no use in terms of the law per se. Secondly, we need that priority to be a fixed priority. And for the time being, we have a big problem because there are several state water policies which clearly say that drinking water is the first priority, but which have a footnote at the end of that provision, which clearly tells us that the government can reorder the priorities as per administrative convenience. So that obviously is completely unacceptable from the point of view of the human right to water. Secondly, we have that human right to water. The courts have told us many times that it exists. There is no doubt that it is one of the fundamental rights that's protected under the Constitution today, even if it's as a derived right. The problem is not that anymore. The problem is that we have, okay, here I've put it as the shell of the right. We have the basic principle, we know what the right is, but we have no idea, the courts have never told us, and there is no legislation that helps in that sense. We have no idea what the content of the right is. So if you want to know what the content of the right is, basically we have to go back to the Committee on Economic and Social Cultural Rights of the United Nations. That's in what they call a general comment, which is basically an interpretation of one of the rights in the covenant, has provided a rather elaborate definition of the content of the right. But that's unsatisfactory, first because that interpretation is not binding on member states, so it's not like it's something that applies directly in India. And secondly, it's not an interpretation that's been adopted at the national or state level, and hence it probably doesn't reflect or relate to the priorities at the national, state, or local level. So basically, there is a lot of work that needs to be done to ensure that the human right doesn't just remain a concept, because that's really what it is today, but it becomes something that is actually implemented and turned into a right that is realized at the local level, okay, basically at the individual level. Thirdly, and that I guess is something that's already come quite a bit in the discussion this morning in a different way, we need to make sure that the environment or environmental law principles are actually integrated and become central to water law. We know, and because that's the buzz is that the environment is the key to water and water sector reforms, that the environment has been put at the center of all the reforms that are taking place in the water sector. But the problem is, from a policy perspective, it may be that the environment is very much there and is key. From a legal perspective, all that has been done is to put the environment as a pretext for the legal and economic reforms that have been introduced. In reality, the environment has not been integrated in